up and
okay, preparing to live stream the meeting. Setting up your meeting for YouTube Live.
it says it's now streaming, is it not yet? No.
Done redirecting to YouTube. Okay, yeah. Setting up your meeting for YouTube Live.
It says it's now streaming, is it not yet? No. Oh, I get an echo, Mark.
Yeah, I know. Okay. Yeah. Right, I just clicked it to get rid of it, so I'm hoping that it's continuing. Okay.
Okay, so welcome everybody to our third Kurdish Tuesday. Just to introduce myself, I'm Sarah Glynn. I'm co-convener of Scottish Solidarity with Kurdistan. Just a little bit of housekeeping then. So everybody's been muted when they come in, which is a sort of security thing. I'm sure you're all lovely, but I don't know who you all are. We've not activated the general chat, but there will be time for questions at the end. And you should be able to send questions directly to me, Sarah Glynn. If not, if that doesn't work, you'll have to send them to Mark because, or basically you can put your hands up, so which is the easier way of doing it, because we want people to be able to ask questions directly. No need to turn your videos off unless you yourself are having trouble getting a signal, because I think it's much nicer to talk to faces than to blank screens. This will be recorded, as you know, and it's being live streamed to YouTube if we've got it set up properly. So we've set up these Kurdish Tuesdays to provide a regular opportunity to discuss Kurdish issues, and with meetings organised by different groups. And so for this third Kurdish Tuesday, we're very excited to welcome the Belgian lawyer, Jan Fermon, who led the legal team that successfully argued in the Belgian courts that the PKK should not be considered a terrorist organisation. It's fair to say that tonight's important topic affects all our campaigning for the Kurdish movement. The decade-long case that Jan led and that he's going to tell us about could prove hugely important in breaking down the wall of criminalisation that surrounds the PKK, and that's basically used to hamper and threaten every action that any of us takes for the Kurdish cause. I'm just a bit puzzled why, I mean, it's lovely seeing your face, Mark, but are we going to see this, are you seeing you or?
No, I'm seeing you. I think we're all seeing
me.
You.
Okay. Okay, that's all right. So long as when it's Jan, we see Jan. That's the important bit. Okay. Then after Jan has spoken, we'll hear from his English colleague Stephen Knight, who's a barrister in London, and who will say a few words about the situation here in the UK and help us see how the Belgian case might impact on a wider context. So our speakers are obviously both lawyers, and they'll be talking about the legal arguments. But of course, laws don't emerge from a vacuum, and what counts as terrorism and who's designated a terrorist are political decisions. So many of us may have a sort of common sense view of what constitutes terrorism, but that may be very different from the definition our politicians have passed into law. Lawyers have to work with the law as is, but we also need to question how the law is this way and be aware of how it can deliberately restrict the right of resistance, even resistance to oppression. I think Trump's designation yesterday of Antifa as terrorists could act as a wake-up call for some people here. So our discussion tonight comes at a time when the UK government is bringing in even more open-ended and controlling anti-terrorism legislation. And when a British father is being tried for sending money to his son who's fighting as part of the YPG, the people who defeated ISIS. Kurds in the UK, as in other parts of Europe, feel the pressure of terrorism law that panders to our NATO ally, Turkey. So here in Edinburgh, over the last 3 years, our local Kurdish community has faced police raids on their homes and their community centre. They've suffered arrests and charges of terrorism. So far, the authorities haven't put together a case to be heard in court, but the whole community is already being punished for its support for their fellow Kurds and their mutual struggle for rights and freedom. Due to the legal sensitivity of their situation, we wouldn't want to ask anybody who's directly involved to describe what's happening, but they have written the following statement for me to read out. The Kurdish community in Scotland are used to all forms of state oppression from past memories in Turkey. But that's what we escaped from. It's the reason we left our loved ones, our land behind. 20 years ago, when we migrated to Scotland, we openly expressed ourselves to the officials. We told them we didn't view the PKK as terrorists, as murderers, but rather as freedom fighters, human rights defenders. We are first-hand witnesses of mass genocide and policies of denial by the Turkish government. We know who burnt our homes, our farms, our villages. During the last 3 years, families in Edinburgh have had their homes raided at dawn numerous times. They're fed up with being treated like terrorists, having their homes raided in front of their children, sometimes as young as 1 year old. They are mentally tired of waiting for court citations to appear in their letterboxes. As a result, many of them are refraining from coming to our centre, participating in cultural classes and social events, and interacting with others. Aside from the psychological damage this is having on our community, it has created a gap we're trying to fill. We're a working community, and on top of the social and economic issues we are battling within our daily lives, we're now trying to bring our affected individuals and families back into the community. The actions of the police have not only criminalized our community, which has built its foundations on values of peace, democracy, and unity, but they've also created feelings of hopelessness and loneliness, the exact feelings we were promised not to experience again when we were welcomed to Scotland many years ago. I know other Kurdish communities have similar experiences to relate, so I'm sure that we can all enjoy this all too rare pleasure when discussing relations with government authorities of hearing about a victory. But just before Jan speaks, we will just have a few words from Chris Stevens, who is the MP for Glasgow South West and has been a long-standing friend of the Kurdish cause and of our Scottish Kurdish community. So if we can hand over to Chris. Chris? Oh,
yeah, unmute him.
Unmute him.
Yeah.
Yes, thank you, Sarah, and thank you for that statement there on behalf of Kurdish community in Scotland. Very much aware of the Kurdish community in Scotland and the UK, not only facing that pressure from the police, but also on social media, where we see Facebook, for example, blocking accounts and suspending accounts for raising the Kurdish issue. So I think it's important that that statement was made. Apologies in advance, I won't be able to stay for all of this, but I do want to welcome Jan and Stephen Knight to the meeting and thank them for everything they're doing for the Kurdish cause. I'm sure there'll be many who will join and ask questions later. Very impressive work that both Jan and Stephen have done recently. Now, you'll know some of the background, folks. The European Court of Justice ruled in April 2018 that it was unrightful to label PKK as a terrorist organisation. And many of you will know that many members of the European Parliament that Britain had at the time voted that PKK should not be designated as a terrorist organisation. I know my colleagues, SNP colleagues, voted that way. We cannot and we must ensure that the Kurdish freedom struggle cannot be accused or designated as terrorism. We're looking for a political solution to what's going on. Certainly, many members of Parliament, including myself, have continued to put pressure on the UK government in terms of how it's dealing with Turkey, making sure that we're looking at the arms sales that's going to Turkey and making sure that the Foreign Office and the UK government continue to use their pressure on Turkey and how it's dealing with the Kurdish community, politicians, academics, journalists, and the like. So I just want to express solidarity with everyone here tonight, solidarity and support to PKK, solidarity and support to the HDP MPs who are currently imprisoned in Turkey, and to state again that for a solution, we want to see the end of the isolation of Öcalan, and we think that Öcalan should be free, and the criminalisation of Kurdish rights needs to end by Turkey. These are crimes against humanity and they're crimes against democracy. So thank you, Sarah, for allowing me to say a few words, and anything I can do for the Scottish Solidarity for Kurdistan campaign, any questions you want me to raise, any motions, parliamentary motions you want me to raise on this issue, that will be done, and I'm looking forward to hearing Jan and hearing the rest of the discussion. Thank you.
Thanks very much, Chris. That's great, and yeah, we will definitely make you work. We promise. So now, really happy to hand over the floor to Jan Fermon. I've heard him speak in Brussels, and I'm just really looking forward to hearing it again. So Jan, the floor is yours.
Thank you, Sarah. Good evening, everybody, and thank you for giving me the opportunity to discuss with you what I think is an important decision in the struggle against the criminalization of PKK and the Kurdish movement throughout Europe. I will try to give you very shortly some background on the case, because I think it's important that the participants do understand what this case was about. Also, I will give some background, not on the case as such, but on what led to the case, which I think is also very interesting for those who have been working in solidarity with the Kurdish movement. First of all, the Belgian case was a criminal prosecution against, at the end, 42 individuals, actually 40 individuals and 2 entities, 2 broadcasting companies, for participation in the activity of a terrorist organization. The main arguments or the main points that were argued by the prosecution as being forms of participation in the activity of a terrorist organization were financing, recruiting, and propaganda activities. So there was no other nature or no other type of action here that was discussed. There were, of course, no acts of violence. It was about making propaganda, collecting funds, and recruiting also for PKK. The case started formally was started formally by the federal prosecutor, which is the national anti-terrorist prosecutor in Belgium, in March 2009. Under the Belgian law, then, in a criminal investigation, a judge, an investigative judge, like in the French system, for those who are familiar with that, conducts an investigation, collects the evidence, and then at the end of that process, a court has to decide whether there is going to be yes or no, whether there is sufficient evidence to make a court case. And the case stranded now at this phase, which is actually a preliminary phase. It's a phase before the actual trial phase. The investigative judge conducted the investigation from 2009 until 2013, actually. During that period, he raided offices, questioned witnesses, tapped phones, collected all kinds of evidence. actually also arrested some of the people for a very short period because they were very quickly released. And in 2013, the judge then decided that the investigation was complete, that there was nothing more he could do to discover the truth. Under the Belgian proceeding, the case is then first handed over back to the prosecutor. And the prosecutor then has to decide whether he wants to bring charges, yes or no. Of course, the federal prosecutor brought charges for leadership or participation in the activity of a terrorist organization. And then the case goes to this preliminary court to be heard, not on the matter whether the defendants are guilty, yes or no, but on the matter whether there is sufficient evidence to start a trial. And at that point, we raised an argument saying, actually, this is not a matter of terrorism. This is a matter of a civil war between, on one hand, the Turkish state, and on the other hand, the Kurdish people. A civil war or an internal armed conflict of this nature is not, cannot be dealt with under the anti-terrorism law. There's a provision in Belgian law, but not only in Belgian law, also in European law and in almost all international treaties on terrorism, which says that violent acts committed in the framework of an armed conflict as defined by international law by a party to that conflict cannot be dealt with under the anti-terrorism laws, but should be dealt with under international humanitarian law, which means the laws of war, the Geneva Conventions. And so we argued that this was not a matter of terrorism, that this was a matter of an armed, a non-international armed conflict between Turkey on one hand and the Kurds, and in particular, of course, PKK and the HPG on the other hand, and that therefore the law ruling this conflict should be international humanitarian law. If any crimes are committed in the framework of this conflict, both the state party, the Turkish state, and the non-state party, in this case PKK and HPG, can of course be, or at least individuals belonging to each of the parties can be prosecuted for war crimes, but not for terrorist crimes. When we developed this argument, there were two interesting aspects to it. One is that at the very beginning, the prosecutor actually laughed it away. The prosecutor said, this is rubbish, this is nonsense. What is this kind of argument? This is just nothing. And we actually, to be very honest, when we discussed within the team whether we were going to raise this argument, yes or no, we were very skeptical about the chances of success. Not because we thought that from a legal point of view we were wrong, because we were convinced we were right, but because we thought that for political reasons, such an argument would never pass. And I'll get back to that in a second. And the second thing is that it also requested some mental reconversion on our behalf. Because actually, in order to decide whether a situation is a conflict and whether an organization is a party to that conflict, there are two main criteria, two basic criteria. The first criterion is the question of the intensity of the conflict. And the second criterion is whether the non-state party, in this case PKK, is sufficiently organized to really conduct a war. And the questions of intensity and organization are measured by there are all kinds of sub-criteria. For example, firepower. Does the non-state actor have sufficient firepower to really conduct a war? Are they organized as an army? Do they have means of communication as an army? Are there sufficient, is the number of attacks big enough to be considered as a war? And so from the discourse we generally have, and I think you also generally have that kind of discourse about the Kurds wanting a political solution and not being nice and not wanting war and not being involved, etc., etc. Suddenly we were into an argument about the PKK having the capacity to bring down helicopters and airplanes, having massive firepower, having artillery, and having the ability to attack in a regular attack, in a regular guerrilla attack, bigger army units. And so that was some kind of a mental reconversion to us, because instead of the gentle Kurds, we were now arguing about the capacity of the Kurds to beat up the Turkish army, which was somehow interesting. The reason why we thought that it was going to be politically very difficult to pass this, to get this argument through the court, was actually because we were aware of the prehistory of the case, because this case did not come out of the blue. This case actually is the logical consequence of a previous case that was conducted by the Belgian judicial authorities against MedTV, against and Rosh TV, against the Kurdish television broadcasting companies who have their studios in Belgium. At the end of the 1990s, the Belgian authorities conducted a case against Met and Rosh with the clear intention to close down both the whole television complex and everything related to it. That case collapsed in the criminal court. I think it was 2002, if I remind it well. Then, when the criminal case collapsed, and so there was no way through the criminal court to stop the work of Kurdish television in Belgium, actually the tax administration came in and tried to put very, very heavy tax fine on the Kurdish television. That case, the tax case, which was about millions of euros, collapsed in 2006, but already in 2005, it was clear that it was going to collapse. And in 2006, for the first time, the Belgians are contacted, well, probably not for the first time, but from what we know now, Belgian authorities are contacted by a Turkish delegation that brings a file about the Kurdish organizations in Belgium trying to revive the case against the Kurdish television, but also to extend it to the Kurdish National Congress and other Kurdish organizations in Belgium representing the Kurdish community, and of course considered by the Turkish authorities as being PKK affiliated. And so the Kurds come with some materials and try to discuss with the Belgians a new crackdown on these organizations. And the Belgians initially are very reluctant because they had this long case against MedTV, which just collapsed dramatically shortly before that. And also, actually, the Belgians, I think, were a little bit fed up with doing the dirty job for the Turkish authorities. And so, in the beginning, they are very reluctant. In the beginning, and also the materials provided by the Turks are very bad. Actually, one Belgian official says, well, these are propaganda brochures and not not criminal files. And whatever you describe in these files in Belgium is actually protected by the freedom of expression. And so there's no criminal case for us there. And then the Turks do what some children do. When they can't get what they want, they go and get their bigger brother. They bring in the elder brother to threaten the other kid. So that's exactly what the Turks did. They turned to the US Embassy, and the US Embassy started in 2006 organizing meetings with Belgian officials and with Turkish officials. And the reason we know about this is because when this case for the first time came to this preliminary court in 2016, we actually knew about this whole phase from 2006 to 2009, essentially, because all the cables from the US Embassy were published on WikiLeaks. And so we could follow every step of this process from 2006 to 2009. 2006 when the Turks first called their bigger brother in, and 2009 when finally under very high US pressure, the Belgian prosecutor starts formally the criminal investigation. When I say very high pressure, it is very high pressure. There is a whole series of meetings. There are 3 high-ranking, high-level US delegations that will travel to Belgium. One in November 2006 with Principal Deputy Counterterrorism Coordinator Frank Urbancic, who came to Belgium and had with a delegation, had a whole series of discussions. Department of Treasury Advisor on Terrorism, Justin Serafini. So there's a delegation of all kinds of US departments, State Security Service, Federal Police, etc. And they meet Belgian officials, both from the Ministry of Foreign Affairs and from the prosecution and the police services, and put very heavy pressure on them to crack down on the Kurdish organizations. A second delegation is in November 2007. 1 year later, again, the Turks send in the US sends in a delegation which meets again all relevant Belgian agencies, including the federal prosecutor, putting pressure again to start cases to crack down on the Kurdish organizations. And finally, we also knew it because of the WikiLeaks cables. In October 2008, and I think the date is important to remind, in October 2008, a delegation composed of the Belgian Ministry of Foreign Affairs, a Belgian Minister of Justice, and the Belgian Minister of Interior, which is, well, actually 3 senior cabinet ministers, go to Ankara on the invitation of the US and the Turks to discuss the matter. And then, so October 2008, the 3 ministers go to Ankara, and then in March 2009, the federal prosecutors formally open the investigation. And I think the chronology is very clear. This is a case, this is an investigation which started from what the Belgian officials call the propaganda brochure and ended up with under tremendous diplomatic pressure, ended up with a formal investigation conducted by the federal prosecutor. So when we started the case, and when we started to, actually not when we started the case, but when we started to argue the case in 2016, before the preliminary court, and when we raised the argument that this was actually an armed conflict and therefore should be dealt with under the laws of war and not under the anti-terrorism laws, we thought that from a legal point of view, from the point of view of law, that was a very correct point. That was we were absolutely right from the legal point of view. And we were convinced that we had no chance from the political point of view. But we actually thought it was important to raise the question nevertheless, to show how the criminalization of the Kurds actually forces European governments even to deny international law, to deny basic human rights such as the freedom of expression, etc. Because in many situations, that's probably the best you can get in this kind of cases. It's ripping off the mask and showing what is behind the reality of the nice words on one hand, human rights, and on the other hand, on the very aggressive words on the Kurds. And actually, so we were really very reluctant ourselves, and to our big surprise, it worked. Maybe because the prosecutor probably made a mistake in the beginning of the proceeding, because when we raised this argument, as I told you, he laughed it away. He said, "Oh, this is ridiculous, and anyhow, this is not for a preliminary court, and we'll discuss this later, but this case has to go to trial," which was, from a tactical point of view, rather stupid towards this judge in the preliminary court, because when the prosecutor argued this judge in the preliminary court said, "Oh, so you think I'm not good enough to deal with this?" And so we had a kind of, well, somehow tactical advantage there. This preliminary court then in September 2017, for the first time, dismissed the whole case and said, this is actually everything you are referring to, all the violent actions you are referring to consider, which are the basis on which you consider PKK to be a terrorist organization, are actually violent actions in the framework, violent actions in Turkey, of course, are in fact violent actions in the framework of an armed conflict. And to an armed conflict, terrorism law simply doesn't apply. Now, as I said previously, I think that's important, because if you apply terrorism law, anti-terrorism law, then of course, to parties in a conflict, then of course you deal very differently with both parties. If you deal with a conflict under anti-terrorism law, then by definition, any use of violence by the non-state party is a criminal act, is a terrorist act. And every action undertaken by the state is by definition not a criminal act. If you deal with it under the laws of war, then you have both parties who are bound by the same laws of war and who can both commit or pose acts of war, commit acts of war, which are legitimate acts of war. For example, attacks on military targets, attacks on the troops of the other side, which are allowed under the laws of war. And both can also be held responsible for war crimes, because, which is impossible. You can't hold the state responsible for a terrorist crime, but you can hold the state, or at least state actors, responsible for a war crime. So applying the laws of war instead of the anti-terrorism laws meant that, first of all the attacks committed or done by HPG and PKK against military targets in Turkey were not to be considered as criminal acts by the Belgian justice, and were no ground to classify or to consider PKK as a terrorist organization, because these were legitimate acts of war. And on the other hand, it opened also the perspective of putting on the same leveling to criminalize the war crimes committed by the Turkish authorities, the war crimes committed by the Turkish. So both from a practical point of view, because it allowed to dismiss this criminal prosecution and to have a decision saying PKK is not to be considered as a terrorist organization under the Belgian criminal law. But from that point of view, which of course has very strong practical consequences, because that means that from now on, collecting funds for Kurdish organizations, expressing support for PKK is not considered anymore as propaganda for a terrorist organization, or so it means that it reestablishes the freedom of expression and the freedom of organization for the Kurdish organizations in Belgium, because supporting a party in a war is not a crime. So it has both very strong practical consequences. It also has, I think, important symbolic meaning, because for the first time, a court has said, wait a second, this is not about bad Kurds attacking this nice Kurdish state. This is about a state fighting an internal insurgency in a widespread conflict. And so actually, our position should be towards that conflict a kind of neutrality. Our position, not political neutrality, but legal neutrality. Both parties are bound by the same laws of war, and both parties can be held accountable if they violate these laws of war. For example, if they commit. So it's also from a symbolic point of view, it brings actually PKK and HPG to a different level than what it was previously. The prosecutor, of course, appealed that first decision, the 2017 decision. The case went then for the first time to the Court of Appeal. That is the normal proceeding under Belgian law. The Court of Appeal in 2017, in September 2017, actually upheld the decision of the first court. And in a very long decision at that time, which some of you might have seen, actually in a very detailed way argued why PKK was not to be considered as a terrorist organization under the Belgian criminal law, but as a party, a worrying party. It was also interesting, for example, on the question of the fundraising. The prosecutor said, yeah, but you see these people, they are raising funds and we can't have that here, and we can't accept that people are collecting money here for PKK. Can you imagine? And so actually the court then, in that decision, turned this argument around and said, well, if they are collecting on an international scale funds, and if they are recruiting on an international scale, as you say, and if they have a propaganda machine, including televisions, as you argue, then that means that this is a real party to a war, because this goes far beyond a small organization committing some violent act. This is a party to a war, and not just a small violent organization. So actually, the arguments the prosecutor developed turned against him. The prosecutor then appealed that decision in the Supreme Court, which can only take decisions on points of law. The Supreme Court decided then that on one point, the appeal court, which was actually not a substantive point, it was a rather silly argument brought forward by the prosecutor, and the court didn't respond to it. But actually, the court has the obligation to respond to all arguments. Because it was so silly, actually, the court didn't take it into consideration in any way. And so the Supreme Court then said, you didn't, your statement of reasons in the decision is insufficient, and send it back, because that's the way it works. The Supreme Court quashes the decision and sends it back to the lower court. Supreme Court sent it back to a different chambers of the Brussels Appeal Court. And again, we argued the whole thing for months. But unfortunately for the prosecutor, on the 8th of March 2019, this second appeal court actually took an absolutely similar decision. And I think some of you probably saw it and have been able to read it, because there's an English translation of that decision which is available. The prosecutors appealed it the second time in the Supreme Court, and then the Supreme Court upheld the decision in February of this year, which means that on January of this year, which means that the decision, the last decision of the appeal court is now final and cannot be challenged anymore in a Belgian court. As well, we can go into some of these points during the discussion. As Chris Steffens said very shortly during his intervention, actually there was a parallel movement, which I think is also interesting because it shows also that things are moving in relation to criminalization of the PKK. As you know, PKK has been included in the European assets freezing lists of terrorist organizations, I think since 2003 or 2004. And PKK actually challenged that decision, or the series of decisions, because actually it's a new decision every 6 months. The list has to be reconfirmed. And so PKK challenged that in 2014 in the European Court of Justice in Luxembourg. And on the 15th of November 2018, the General Court in Luxembourg actually issued a decision cancelling all the inclusions of PKK, all the decisions to include PKK in the European anti-terrorist and assets freezing list since 2014 until 2018 for purely procedural reasons, but really only for a procedural matter. The very last decision, which was actually taken a few days before I think the court dealt or handled the case, for procedural reasons, that very last decision could not be included in these proceedings. And so actually that decision was not cancelled, not because it was different, not because it had a better statement of reasons, not because it was sufficient, the statement of reasons was sufficient, but simply because for procedural reasons it could not be included in the series between 2014 and 2018. Actually, this last decision was taken exactly on the same grounds, as the decisions between 2014 and 2018. And so my Dutch colleagues who dealt with that case, they immediately also challenged in the European Court of Justice that last decision, which fell out of the proceedings, the period of the proceedings, and of course all the new decisions that have been taken in the meanwhile, because the European Union, as if nothing happened, simply continues to include the PKK again and again every 6 months in the list, again and again on the same statement of reasons that was found insufficient by the court for the period 2014-2018. So that is pending now, but I think it's also an important development, because if you read through the decision of the General Court, it also shows that the General Court, to some extent, if you read between the lines, it says a little bit the same as what the Belgian officials said. There are materials provided by the Turks. That materials anyhow are not sufficient. And actually there is not much more than that. National courts have been taking decisions based on Turkish materials. These Turkish materials have been proven to be unsound. And so these national court decisions, which have been turning around in Germany and France, etc., actually don't have much more weight than the initial materials provided by the Turkish authorities. The European decision refers, for example, to a list of incidents that occurred in Turkey. And the Belgian prosecutor actually brought the same list of incidents into our proceedings and said, look how terrible the PKK is, look how bad and how violent they are. But when we analyzed that list, and we could see that there were actually in that list, of course, a series of actions against legitimate military targets, which for the Belgian proceedings were anyhow considered to be out of the scope, but also a series of false flag actions, a series of actions which subsequently showed or were shown to be actually actions taken by the Turkish army to put the blame on PKK. There were some of the incidents in which initially the Turkish authorities said, well, this is PKK, arrested some people, said these people are linked to PKK. So you see, it's them who committed these acts. And where even Turkish courts, in the meanwhile, acquitted these individuals and said, we have no idea who did this. We have no evidence whatsoever who did this. Still, the European courts, the European Union, and the prosecutor in the Belgian court just put forward these incidents as being proven committed by PKK. Now, and I'll just finish on that. To some extent, initially we were a little bit worried because the Turkish state actually participated in the Belgian proceedings as a civil party. That is possible under French and under Belgian law. Anybody who is prejudiced by a criminal act can participate in the criminal proceedings and actually has the possibility to discuss the evidence, guilt, but of course also the damage. But civil parties have a very big role in criminal proceedings. They have a very strong possibility to intervene. And so the Turkish state actually was a civil party in this proceedings. And initially we were worried because, of course, we had two prosecutors, a Belgian prosecutor and a Turkish prosecutor, represented by a Belgian lawyer, but we were fighting on two fronts. But then actually it at the end it was to our advantage, because what happened is when the Belgian prosecutor said, look how these, for example, look how PKK blasted a bomb in whatever in Ankara on this day. And so it's a terrorist organization. We said, okay, well, we're very much interested. Where is the evidence? Where is the criminal file? We suppose that Turkey has conducted a criminal investigation into this. If Turkey didn't, we are very surprised, because then Turkey is a failed state. So we are very much convinced that Turkey has conducted a very serious criminal investigation into this, that they analyzed the bomb, that they analyzed where the explosives came from, that they had analyzed the detonation mechanism, that they tapped phones to know who bought this detonation mechanism, that they took fingerprints, etc. Can we see the evidence? Because if that evidence shows that PKK is involved, then we might have to walk out of the courtroom and forget about all this. But up until now, we didn't see any evidence. And actually, and I think that worked in our favor. We really challenged the Turkish state on some points on this. We really turned to them and said, well, where are your materials? Where is your evidence? Come up, show it. It's your chance. Give it to the Belgian, give it to the court, show it to the court. And the only thing the Belgian lawyer did, representing the Turkish state, was looking at the points of his shoes, trying to avoid to look in our direction or in the direction of the court, because he had nothing, absolutely nothing. Now, we then said to the court, well, there are two possibilities. Either they don't want to show it, because there's something embarrassing to it, which is a problem, or they don't have it, which is also a problem, because then the allegation that this is PKK is just mere propaganda and not based on anything serious, But anyhow, the fact that they don't come up, that they have the opportunity to bring all this evidence to the case, and that they don't show anything, is a serious problem. So you can't hold PKK responsible for some of these acts like bombing in cities, etc., based only on these very light allegations. And so I think these elements taken together convinced the Belgian court that this was a problem which should not be dealt with under anti-terrorism law, that it should be dealt with under international humanitarian law, that if the prosecutor wants, the Belgian prosecutor wants to prosecute somebody, he has to do so for war crimes and not for terrorism acts. And of course, all the evidence, or the so-called evidence of war crimes committed by PKK, we know that Turkey has never been able to come up with something which is somehow serious. So the decision being final, as I said, the Kurdish organizations are now free to move in Belgium, free to do their work, to work in the European Parliament, to express themselves, to organize demonstrations, peaceful demonstrations whenever they want, to set up media in Belgium, to organize solidarity. And I think that is very important. And I think it's also important to try to somehow export this decision, or at least try to use it in other jurisdictions. First of all, because it's a decision which is based on Belgian law, but also on international law, because the clause in the Belgian law, which says that parties to a conflict, acts committed by parties to a conflict cannot be judged under anti-terrorism law. It's not Belgium who invented that clause. It's a clause which is in all international treaties on terrorism. It's a clause which is in the European Directive on Terrorism. And so it's international law, actually. And then, of course, there is a discussion on to what extent it's binding to other countries, etc. That also depends on the national system. But it's actually a principle of international law that whenever there is a conflict, an armed conflict in a country, it should be ruled by international humanitarian law, and parties should be considered or should be dealt with on a level of some level of equality, but not criminalizing one and allowing the other party, the state party, to do whatever they want to do. So these, I talked longer than I promised to do, but I'm sorry, but it needs some background, I think, for your listeners for the participants to understand what this case is about.
Thank you very much, Jan. And yeah, I could have gone on listening for a lot longer. That's absolutely fascinating and encouraging too, which, my goodness me, we need. And I'm now going to hand over to Stephen Knight, who's a barrister in London, to try and put a bit of a UK perspective on it and how this might impact on things here. So, Stephen.
Thank you, Sarah, and thank you, Jan, for that very detailed discussion of the position in Belgium. I'm going to talk about the question of prescription, which is the legal process of banning an organisation as it applies in the UK, and look at the avenues that are open to us to deprescribe an organisation, and in particular the PKK. And what I'm going to try and focus on is a case that we would like to bring within the UK system to attempt to push forward the deprescription of the PKK. Now, to do that, I'm going to talk firstly about the concept of prescription itself and the concept of terrorism in British law. And it was something that was introduced in the Terrorism Act 2000. This process of systematically banning or prescribing various organizations, many of whom communities see as their legitimate political expressions. So to prescribe an organization takes very little work on the part of the government. Essentially, the Home Secretary simply makes a decision that the organization should be banned. And she adds the organization to the list of prescribed organizations, and she can do it simply because she believes that the organization is concerned in terrorism. And that sounds like it should be a fairly simple matter. It should be something that's fairly serious. But it raises the question of what does it mean for an organization to be concerned in terrorism? And to find the answer to that, we just need to look at the Terrorism Act 2000, section 1 of which tells us what terrorism is. And it's actually something that's extremely broad in nature. So an organization could be concerned in terrorism if it does an action which either involves serious violence against a person, well, you may assume that would be the case, or involves serious damage to property, endangers a person's life other than that of the person committing the action, creates a serious risk to the health or safety of the public, or to just a section of the public, or does an action that's designed seriously to interfere with or seriously disrupt an electronic system. And it has to do those actions or threaten those actions in a way that's designed to influence a government or an international governmental organization, or to intimidate the public, or to intimidate just a section of the public. And it has to do it or threaten those actions for the purpose of advancing a political, religious, racial, or ideological cause. Now, that's all a bit of a mouthful. But what does it mean in practice? Well, if we look at the example of the PKK would be shown to be concerned in terrorism if it threatened, for example, serious violence against soldiers of the Turkish state, or threatened to seriously damage Turkish state property. That's enough for an organization to be terrorist in the UK, if it's doing those actions and it's doing them in order to influence the Turkish government. So what we see there is an extremely low bar for treating an organization as terrorist. And importantly, there is no just cause defense to terrorism. You can't say in British law, this organization isn't terrorist because it's acting to protect human rights. It's acting to overthrow a dictatorship. British law is quite clear that an absolute totalitarian dictatorship deserves the same protection as a democratic government. So there's no distinction that's drawn between them. And once you're on the list of prescribed organizations, once the Home Office has decided that you are concerned in terrorism, there's no automatic review of that decision. What you can do, though, is apply to be deprescribed, to be removed from the list of organizations. And I'll come to that in a moment. Now, when the PKK was prescribed, it was within the first batch of organizations that were banned under the Terrorism Act that were prescribed. And that large group of organizations that were prescribed included the PKK. It included other organizations that some see as being legitimate expressions of their community. For example, ETA in the Basque homeland, the GHKPC, also active within Turkey, and other groups that were, on some analysis, seeking national liberation. Now, interestingly, also prescribed at the same time was Al-Qaeda and other extremist Islamic organizations, but also the political, the armed wings of both Hamas and Hezbollah. But when Hamas and Hezbollah were banned in that same group of organizations that were banned as the PKK, it was only their armed wings that were banned, not their political wings. Whereas with the PKK, what we saw was the entire organization was banned, not just their armed wing. So what you might think there is that a political decision was taken by the Home Secretary as to which organizations to ban and which not to ban, and which parts of certain organizations to ban and which parts not to ban. But the Home Office, the Home Secretary are allowed to make that political decision. That's part of the discretion that they're given by the legislation, the Terrorism Act, and that's intentional. The government introduced the Terrorism Act in order to be able to pick and choose which organizations that they were going to ban and which they weren't. So that deals with the prescription of the PKK and when it was prescribed. But how can it be deprescribed? How can we get it off the list of banned organizations? Well, an application can be made for it to be removed from that list, but that application is made to the Home Secretary, the same person that's responsible for putting the organization onto the list of banned organizations. And of course, anyone who's making an application on behalf of the PKK or any other banned organization is necessarily going to be in a bit of difficulty because the PKK is banned. How can the PKK then apply to be taken off without the people who are doing the application coming into some legal difficulty and being prosecuted for being members of the PKK? It would be a complete catch-22 situation, but there is a certain immunity that people have if they're making the application. The information that they give to the Home Office in order to make the application can't be used against them for certain terrorism offences, including the offence of being part of the organisation. So there is a certain level of protection there for the person making the application, but it's not perfect. And even though the Home Office can't use the information that you give them in order to prosecute you, if you weren't a British citizen, they could still use the information in order to remove your leave to remain in the UK, or they could use the information that you give them to prosecute someone else. So it's not a system without risks, but there is that opportunity there to make the application for deprescription. The question then is, how does the Home Office actually approach that application made by or on behalf of the PKK to remove it from the list of prescribed organizations? Well, there is a two-stage test in law that comes from another case dealing with a completely different organization, the People's Mujahideen of Iran. They brought a case asking to be removed from the list, and they were taken off the list. And the test is, it's a two-stage test. Firstly, under British law, is the PKK actually concerned in terrorism, as Britain defines what terrorism is? And the second stage is essentially a discretion that the Home Office and Home Secretary have as to whether to remove, even if the PKK is involved in terrorism, then to remove it anyway from the list. And in exercising that discretion, there are a number of things that the Home Secretary, Home Office would consider, and that have been considered in other similar cases. Firstly, they'd be looking at the nature and scale of the organization's activities. So essentially, is it important enough to be added to a list of banned organisations? Secondly, the specific threat that the organisation poses to the UK. Now, the PKK, you may think, poses no threat whatsoever to the UK or to the UK's interests, given that its activities seem to be limited to Turkey and the surrounding region. The next thing that they'd look at is the specific threat that the PKK poses to British nationals overseas. And again, you may think that the PKK doesn't actually pose a threat to British nationals overseas. The only people that it would pose a threat to would be Turkish members of the Turkish security apparatus. Fourth thing that they would look at would be the extent of the organisation's presence in the UK. So is it something that's really relevant for the UK to actually look at banning? And finally, the need to support international partners in the fight against terrorism. And this is where that real political decision-making comes in as to what organisations are banned and then removed from the list of banned organisations. Because Turkey is one of the UK's international partners in the fight against terrorism. So the Home Office will consider, well, if we remove the PKK from the list, is that going to undermine our partner Turkey's fight against terrorism? And of course, you might assume that the Home Secretary would say, well, yes, it would undermine that. So those are things that the Home Office have to consider. But what we also think that they should consider is the point that Jan has dealt with in the Belgian case, and that's that the fact that the PKK is, or appears to be involved in an organised non-international armed conflict, that it is in a civil war against the Turkish state. And we can say in an application to be removed from the list of banned organisations that that is a major factor that the Home Office should consider. Essentially, that we shouldn't be getting legally involved, as Jan talks about, in the civil wars of other countries. Now, that's the test that the Home Office would be applying. You can bet with a very high degree of certainty that the Home Office, if you applied to remove the PKK from the list of banned organisations, would just say no. They would refuse the application. And so there's a right of appeal to an independent commission. In that appeal, the Home Office can rely on secret evidence. No doubt that would include the sort of material that Jan has talked about, Turkish propaganda about the conflict with the PKK. And you can bet that that material would be withheld on national security grounds, essentially saying that anyone challenging the PKK can't look at the evidence. Sorry, anyone challenging the ban on the PKK can't look at the evidence because it would undermine British national security interests and Turkish national security interests. What we'd hope to do, of course, in a case brought in the UK is use the example of what's happened in Belgium to show that a British court can't rely on evidence put forward by the Turkish state, because that evidence simply doesn't stand up to scrutiny when scrutiny is allowed to be applied to it. I'm going to wrap up by talking about the ideal applicants that we have in this case, and then hopefully the floor can be open to questions. But it's what we would be looking for is people who have a secure status in the UK, so people whose immigration position isn't at risk, so primarily British citizens, and not dual nationals or people who would want to travel to Turkey, because you can bet that anyone who puts their head above the parapet as a client in this sort of case would be prosecuted by Turkey if they were to ever travel there. On this call along with me is my colleague Paul Heron from the Public Interest Law Centre. He's been working with me on the case that we are trying to bring with regard to the deprescription of the PKK. And we'd both be happy to answer any questions either on this call or perhaps later if anyone is interested in getting involved in the case, particularly if anyone would want to be considered as the client to actually bring the case to have the application to deprescribe the PKK. I recognise I've gone on for quite a while already, so I'm going to mute myself now and hand back over to Sarah.
Thank you very much indeed, Stephen. Can I just before you disappear and we open up, when you're saying you'd be looking for somebody, presumably would that would be a Kurdish person who, I mean, what would qualify apart from having British nationality for them to be that person? Yeah.
It would be necessary for them to have a direct interest in the case. Now, your sort of ideal client, or the person that the law sees as the ideal person to bring this case, would be a member of the PKK, because they have an obvious interest in the PKK being deprescribed. But as I've said, even though there is a limited degree of immunity from being prosecuted as a result of bringing the case, saying that someone is a member of the PKK still puts them at risk. So we're not asking for a PKK member to come forward and bring the case. What we're asking for is people who are directly affected by the PKK's prescription to come forward. So members of the community who are harassed by the police, who aren't able to enter the country without being stopped under terrorism legislation, members of the community who aren't able to participate in community groups without interference from the police. That is the sort of person that would make for the ideal claimant or applicant to bring this sort of case, because they're not in the immediate legal danger of saying that they're a member of the PKK, but they still have that direct impact on them from the ban on the organisation.
Thank you. That's lovely and clear. Just before opening up to the floor, thank you both very much. I mean, it's absolutely fascinating. And yes, and helpful, and you know, it feels that there's things that are happening and more can happen. Just before opening up to the floor, I just want to do a brief announcement about our next meeting in Kurdish Tuesdays, a fortnightly thing. So in 2 weeks' time, on the 16th, the meeting's going to be organised by Boycott Turkey, which I think the subject is in the name of the organisation. If you want to do any homework on it, they've got a website, which is boycott-turkey.net. So that's in 2 weeks' time. And now, yes, has anybody?
Sarah, can I just mention, I wasn't quite sure if he was able to make it, but we have in the room Alistair Lyon, who, is he still here? Who has done a lot of,
yes.
Yeah, could you, Alistair, can I invite you if you like, to see if you want to say a few words? Would that be okay? So, I mean, Alistair has done such a lot of work on this topic.
Meanwhile, others, please think of what.
Hi, can you hear me?
Yes, Alistair, we can hear you.
So, forgive me, I'm just about to lose all my battery, but I'm trying to keep it going. But I should be okay.
I'm so sorry to just put that on you like that, but I thought it would be such a waste if we didn't hear a few words from you.
No, well, thank you. I mean, for those who don't know, I'm a solicitor at Bernberg Pierce, and we've had the privilege to represent members of the Kurdish community over many years in all its formats. And I have to say that the experience this side of the border is I'm afraid the same as it is in Scotland, and this the government here has always been quite happy to harass members of the Kurdish community. yet has never dared actually treat them in a way that it should do if it was being honest with itself. So there have been a series of raids of community centres in London, as in Scotland, and harassments in the form of MI5 visits, huge amounts of border stops, but very rare prosecutions, because of course it's all political. It's very useful that the PKK is designated as a terrorist organisation, mainly for reasons of the politics in relation to Turkey. But I think at least parts of the British state is aware that it's a figment, that it is a terrorist organisation, and as Jan has so clearly shown in his very impressive case in Belgium, when you actually analyse the facts, it's very clear that it's not. What's more worrying, and I can't comment too much about it because it's sort of sub judice, saying that there is due to be a trial of people who've been arrested. One the father of someone who went back reasonably recently, and two others, including one of his sons, where it appears to be that having in relation to events over the border in Syria, they're prosecuting people where, as far as I can see, the activities they are engaged in are precisely the same. They've been fighting against
Sorry, Alistair, just to say that this is being recorded live, just for your information. I don't know if you were in before.
Thank you. Yeah. No. Anyway, no. As I say, of course, I'm limited what I can say, but there is to be a trial which is going to consider these issues directly in relation to Turkey, as opposed to those who have been fighting against ISIS. Although it's on behalf of what is understood and being prosecuted as exactly. So we're undoubtedly in very troubling times at the moment, and it's obviously great that so many people are coming together today to talk about what can be done progressively to improve the situation. Anyway, thank you very much for asking me to make some comments.
Are you hanging around for the questions,
I'm doing my best. I apologise, but my technical difficulties today have been severe, okay. And my phone's about to die. But I've got anyway, I won't bore you with it. But I am trying to. Yes.
Hopefully. Okay. Great. Thank you so much. It's great to have you here. Sorry, Sarah. Over to you.
That's all right. I don't see. Has anybody got any? Nobody sent in any questions, have they, to anybody? Or nobody seems to have a hand up either. We're all just completely overwhelmed by the situation. And I mean, I was wondering if I could ask both of you. I mean, the situation generally, there just seems to be banding accusations of you're a terrorist. It just seems to be, it's just a way of delegitimizing people. Do you see the situation hardening or getting better? I mean, it seems to be, there's laws going through, I think, at the moment in the UK that's going to make it even harder for people who are easier to hold people indefinitely who are being accused of terrorism. I just wondered if you felt, there's different currents. Obviously, what we've just heard, this case is really encouraging, but is it actually coming up against people more determined to build an even higher wall? Do you want to, should we yeah, you can
I think it would be difficult to build an even higher wall than the one that already exists. The system in law is deliberately designed to catch as many organizations as possible, to allow them to be treated as terrorists, and then to give the government, through the Home Office and the Home Secretary, the maximum amount of discretion to decide which of those possible terrorist groups to actually ban. As to the individual actions that are taken against members of those communities, well, the community will know better than I will exactly how bad things are at the moment, how bad they have been. But if you look at the situation in Turkey itself, you'll see how bad they could become if the state made an active decision to increase the enforcement of existing laws against the community.
Yeah, Tony Cox is wanting to ask a question, Sarah.
We don't hear Sarah.
Yes, Sarah, you're on mute.
Yeah, Tony, you should be off mute.
Just to ask about what you think the implications are of the recent pronouncements by Trump with regards to Antifa in the United States. He's going to declare that a terror organization. Presumably, the process by which they actually define a terror organization over there is similar to over here. And on the other issue, I mean, I've got my suspicions that even groups like Scottish Unemployed Workers Network have actually been deemed to be terrorist organisations, considering the way that we actually get treated sometimes, you know, when we're outside the brew and things like that, you know. I think we were wondering about with plastic explosives on us. So I've got no doubts at all that this will actually become more and more an issue rather than less.
Maybe if I can say a word to that. I think it's very obvious that after a period, if you look at it in a slightly longer historical perspective, after the Second World War, there has been a movement in international law to gradually grant some kind of status to non-state actors. And I think that's a logical consequence, first of all, of the war, where, of course, all throughout the world, non-state actors, resistance movements, were heavily involved in defeating the Axis powers. And so inevitably that led to a position which was different from the pre-war perspective, where by definition any action against the state was a criminal action. And it's actually that perspective that allowed also the Nazi occupants in Europe to, even from a legal point of view, to argue that the resistance movement was a criminal terrorist movement and could not be a legitimate. So first the anti-fascist resistance, then the anti-colonial struggles, where of course also all these struggles were conducted by non-state actors, because at that time they were not states, led to, especially in the Geneva Conventions, in the additional protocols to the Geneva Conventions, to a position where international law, to some extent, I would say, gave some kind of position to non-state actors in conflicts and tried to somehow balance the positions of states and non-state actors. Non-state actors have never been on the same position as states, but nevertheless, international law recognized some legitimacy to what, under certain circumstances, what they did. And that's a heritage we have from previous struggles in law. It's obvious that with the anti-terrorist logics, we're back to the pre-war logics, where any action undertaken against the state, whether it's legitimate resistance against repression, or whether it's a liberation struggle or an emancipatory movement or whatever, is again, by definition, not only on the national level, because of course you can't expect national states to say, okay, our opponent in this conflict is a nice, or that's not what it's about. But on an international level, we're also back into a situation where this kind of opposition against the state, by definition, is criminalized. Whether it's a repressive state, whether it's rebellion against uprising against brutal repression, etc. And so actually the whole part also of the preamble of the Universal Declaration of Human Rights, which says that fundamental rights are important, so that in last instance people should not be forced to stand up against tyranny. That part is gone, because today if you stand up against tyranny, well, you're under the anti-terrorist law. That's what Stefan said earlier about the British anti-terrorist law. And it's also, the logic is the same on the continent. I think a point is where we were somehow lucky, where there was a kind of small crack in the system which we were able to use, is that Belgium and some other European countries, they don't have a proscription regime, which means that the decision whether an organization is to be considered as a terrorist organization, yes or no, is a decision by a judge and not by a political authority, at least in the field of criminal law. The political authorities can, of course, they decide on the European listing, but as you go to criminal law and to criminalizing people for solidarity work, etc., it's finally a judge who decides on the question whether an organization is to be considered as a terrorist organization, yes or no. And that's where we were now able to somehow to get into that crack, and to say, well, whatever the political assessment is, that's a different matter. But you have to look into the question whether, from a point of view of law, both national and international law, taking into consideration also this acquis of the international law after the Second World War, whether this can be handled as a criminal action because of the fact that these people oppose a state. And so we had some space to move there, which we then were able to use.
Alistair, would you like to add anything there?
Yeah, I mean, in terms of in this country, I mean, absolutely agree. I mean, it is entirely about the state monopoly of violence. You know, only states have the right to use violence. And in terms of the case law, it's been getting progressively worse. There's a case called Roe, in which it was being argued about self-defense and what do you do in the context of self-defense, which is normally recognized in criminal law as a very protected form of defense, and particularly relevant in political cases. And the idea was, what happens if someone is using self-defense, but is also doing it, also has a religious motivation as well. This was a case of someone who went to Bosnia, and the question of fighting or thinking about fighting there. And the court decided that essentially, if you had a mixed motivation, that was sufficient to be culpable in criminal law for terrorism. So in essence, the only time at the moment it claims that you can, that you might possibly have a defense in terrorism is if you have no ideology whatsoever. So in theory, a mercenary would be not guilty of an offense. You could go and get paid lots of money to fight against, well, whoever you want. You may commit other offenses, of course, but you wouldn't be committing an act of terrorism. The big irony of all of this is that when the Terrorism Act was introduced in 2000 in Britain, and there was a challenge to it, which we had some involvement in. But if you look at some of the debates, it was suggested at the time, people were saying in relation to the Kurds, interestingly, they were saying because of Iraq, they're saying, well, what about the Peshmerga? What about the Peshmerga? Are they going to be, you know, those who are fighting against Saddam Hussein, are they going to be called under this? And it was Jack Straw said, absolutely not, no way, no one could ever imagine outlawing any of these, you know, any of these sorts of activities. And of course, they have done. And when it came in this country, it was done on a all or nothing basis, and it's pretty much remained that. It's state sanctioned to get on the list for terrorism. And when the PKK were put on in 2000, it was a list including Al-Qaeda, some fairly obvious unattractive groups, along with lots of groups that would traditionally be considered to be, insurgencies or however one would describe it. But yeah, it's pretty depressing stuff.
Maybe can I add one word to that? Because actually, all the examples Alistair is citing or bringing forward, including the one on the mixed motivation, etc. We actually had all that also in Belgian courts with very bad decisions, very confused, but also confusing and very decisions going in all kinds of directions, including on the mixed motivation. What makes me hopeful is that there are some cracks, because in this wall, the court now in this decision actually puts to some extent some order in all this. And says, no, the point you have to look at is not what is the motivation of the person. We had some decisions previously saying anybody who wants to participate in jihad is not participating, is a terrorist because the motivation is jihad and not a freedom war, something like that. Actually, the Brussels court now, I think, very correctly says that's not the question. The question is whether this is a conflict under international law. Then you have to deal with it as a conflict under international law. If the actions undertaken by the organization are actions which are part of a conflict as defined by international law, then you have to deal with it on a legal framework based on international law, which of course we felt during the whole case also the shadow of ISIS over the case. And the prosecutor very often used also this and said, yeah, but if you say PKK is not a terrorist organization on these grounds, then tomorrow I will not be able to prosecute ISIS anymore. And so we took that and we said, sorry, but actually that is not correct, because ISIS is an organization that is waging war in the Middle East. And actually, you should prosecute them for the war crimes, the crimes against humanity, the acts of genocide, but you should prosecute those as not as acts of terrorism, but as war crimes, crimes against humanity, and war crimes. You're even under an obligation imposed upon you by the Geneva Conventions and by other instruments of international law to prosecute those involved in war crimes, crimes against humanity, genocide crimes, for those crimes and not for the lesser crime of terrorism. And so at the same time, ISIS is exploding the Brussels metro and is also exploding the Brussels airport, which means that ISIS is an organization with a double nature. So if you want to prosecute them for terrorism for the Brussels metro and the Brussels airport, then fine with us. We don't have a problem with that. But the PKK doesn't explode metros and airfields, and so you should make that distinction. And so I think on one hand, first of all, we were very pessimistic, as I said, and we had everything Alistair says, apart from the fact that in the UK, the political decision, which is an important difference, that's true. But all the rest, we had it in court decisions. And I think in the disorder that provoked, the court now has set some order, which I think was necessary. But so I'm optimistic and pessimistic at the same time.
Sarah, I've got all the.
I've got some questions here.
Okay.
Well.
Okay.
Just for fun. So yes, Henifi, you wanted to, and then we'll come back to Stephen. Yeah, is that right? Is that okay, Stephen? Yeah. Henifi, can somebody unmute Henifi?
I've got Rosa and Stephen are still got their hands up. They've got questions that they've sent to me, so we can ask these. Hanifi, A, B, C, D, E, F, G, H. Hanif, you should be unmuted now. Hanif, yeah.
Okay. Thank you very much. Thank you very much for all the participants and very wonderful presentations, discussion. Anyhow, so I just wanted to ask one question to Jan, and what happens now? I mean, what is the mechanism, if there is any, to use this court verdict to take the PKK off the list of European Union designated terrorist organizations? I mean, if there is a mechanism as such, I mean, is there a way to convert these judicial gains into a political gain? Thank you. Other participants could answer as well, but primarily to Jan. Thank you.
Thank you, Hanif. Of our legal team, who wants to take that question?
I was unable to unmute, but I was able to do it now. Maybe it's addressed to me first, so I can maybe give some. First of all, I think to some extent the political advantage is already there, because it obviously gives a platform to frame the struggle of the Kurdish people in a different perspective than it was framed, and when it was framed in for the last 10 or 15 years. It gives also politically the opportunity to say, wait a second, you're talking about terrorism, but this might be something different. Might be something different going on. And if there's something different going on than terrorism, then you might have to look into it and to think about it and to try to approach it politically in a different way. So I think that already there is some kind of advantage there. There is no direct connection between the listing and the criminal prosecution, because the listing is a political process, whether it's on a national level or on a European level. It's a political decision, actually the dismissal of the case, the prosecution, is a judicial criminal law case. But we have been working very closely during the whole case with our Dutch colleagues who are involved in the case in Luxembourg, which I mentioned at the beginning of the intervention, which is about the delisting. And so we've been exchanging constantly materials because, of course, the prosecutor used also the listing as an argument. He knew it's not, the Belgian judge is not bound by the listing. He knows that the Belgian judge, independently from the listing, can make up his own mind, which is an advantage for us. But of course, he tried to use it, saying, you know, every European country, all the European Union considered it as being terrorist. So how do you want to make another decision? The Belgian judge very clearly says, well, the listing is a political process. That's not for me. I'm looking at whether under the law it's to be considered as a terrorist organization. And to some extent, that is an advantage for us, that it was an independent judicial decision. At the same time, it's clear that my colleagues now, I told you there is a follow-up case in Luxembourg going on. My colleagues, my Dutch colleagues who are pleading this case, are using now the Belgian decision, of course, saying, wait a second, the European listing is established on the basis of national decisions. It's a double trigger mechanism. In order to get an organization on the European list, you first need decisions of local courts in European countries designating the organization or considering the organization as being a terrorist organization, or at least conducting investigations into that. Now we have a court of law from one of the EU states who actually examined whether this is a terrorist organization and came to the conclusion that it's not. So you have to take that into consideration in the listing process. So we are, and at least you have to respond in the listing process to the reasons why the Belgian court did not consider them as a terrorist organization. So we are, at the same time, we have two parallel independent proceedings and paths of action both on government level, prosecution on one hand, listing on the other hand, but we also have two parallel and intertwined paths of defense where we use the decision of the Belgian court to say you have to reconsider the political decision, and the other way around. The court found the political decision unsound, so we want you to take that into consideration. We ask the court to take that into consideration also in the judicial decision. So there is interaction.
Thank you very much. And so I'm going to bring Stephen in, and then I've also got Paul and Nergis.
Rosa was one of the first questions, actually.
Okay,
but it has come to me because I was the host. That's the only thing.
All right, so let's have Stephen, and then we'll have Paul, Nergis, and Rosa, and then we'll have both our speakers coming back at the end.
Yeah,
okay?
So I had a question come to me directly in a private message that I'm going to answer publicly. The question related to an application for deprescription of the PKK in Britain. And it was, can the application be made in a group rather than one client? And the answer to that is yes, and that would be ideal. What you would most want to see is a group of people together saying, we are representative of our community. And in fact, when the PKK was originally placed on the list of banned organizations in 2000, there was a judicial review of that decision, which had over 100 claimants who were bringing that legal case, and many, many more who wanted to be joined into it as well. That case didn't succeed because of various jurisdictional issues that I don't need to go into, but that's exactly what we'd want to see in any application being brought forward now, as many people as representative of the community as possible. And if anyone does want to get involved in bringing that, then, as I said earlier, Paul Heron, who's on this call at the Public Interest Law Centre, would be very happy to speak to you. You can either Google Public Interest Law Centre and his details are on there, or his email address is paul.heron@pilc.org.uk. That's paul.heron@pilc.org.uk.
Thanks very much, Stephen. Can someone unmute? Is Paul still here? Can someone unmute Paul?
Paul?
Yeah. Yes, Paul Christian Nancy.
Oh, right, yes, got it. Yeah, unmuted. Yes, Paul.
Okay, thank you very much. All right. So the question that I had to Jan Fermon in particular was about his analysis of the state of war paradigm versus the sovereign state versus non-state actor paradigm in terms of the right to use violence. So the question is that the United Nations, of course, unlike the European Union, unlike NATO, unlike the United States, does not view the PKK as a terrorist organization. And so is the state of war paradigm, is there room for us in the activist community to really push the UN toward a position which is more balanced between the Kurds on the one hand and the Turkish state on the other? I think the UN is a great example, unlike states such as the United States, where you see this terrible imbalance. So hopefully if Trump is gone in 6 or 7 months, maybe that will be revisited. But in the meantime, is the UN a good advocacy target?
And should we just have those 3 questions and then you can answer all of them? So Nergis?
I think Nergis has already been asked. So Rosa,
was that the question?
That was the first one. Oh, Stephen's got his hand up.
No, I think that just hasn't come down.
Oh.
Rosa, yeah.
Well, unfortunately, Rosa seems to have left.
Oh, has she?
Maybe it's a technical thing. Rosa, are you here?
She's definitely.
Rosa?
Hi, sorry, I'm the other Stephen with his hand up, I think.
Yeah, Stephen. Yeah, it was you that wanted the question, wasn't it?
It was me. Yeah. Sarah's trying to block me.
Yeah, exactly. Sarah, it was Stephen who wanted the question. Here, this Stephen.
All right, sorry.
No, okay, Sarah. Right.
And Akko as well has got his hand up, I can see. After.
Okay, so sorry, is Rosa here then?
Yes, I'm here, Mark.
Rose, okay, do you want to ask your question?
All right, thank you very much. Sorry, I had a few technical issues. I went out and I sent my question to Mark, but it's deleted and it's lost, but it's fine.
I've sent it back to you if you want to.
All right, thank you. I'm sorry about those technical issues. Basically I wanted to first of all to really thank Jan for his hard work and that he's given a hope to the Kurdish community that the Kurdish people can be stopped criminalizing us if we are active in the community. Most likely we are always related back to PKK being a terrorist organization. So thank you so much from the bottom of all the Kurdish community that you have set a precedent that the PKK can be removed as a terrorist organization. And I am more than happy to support Stephen for his work in the UK to try to build a case for the Home Secretary to look into it. But basically, it will be a hard campaign or lobbying because of the Kurdish people being criminalized, and it's hard for members of the PKK coming forward for building that case. So it is very challenging. But I wanted to ask a question. So how many when did you start kind of building this case, and how many people have they've come forward for building this case in the UK? And my question is for Stephen, really.
Should we have all the questions? Is that okay? And then have the two speakers come in at the end. So sorry, Stephen Smiley, and then Akko, and then Tony again.
Okay, thanks, Sarah, and thank you, Jan and Stephen, for the contributions. I'm a member of the National Executive of Unison, which is the biggest public service union, or biggest union in the UK. And I just, in terms of the non-state organisations, I'm old enough to remember when the miners' union were declared the enemy within, and the whole plethora of anti-trade union laws designed to protect the state interest from an employer's interest from workers. And of course, we've also seen how environmental groups, animal rights groups have been labelled in that way, if not prescribed officially legally, but labelled as terrorist organisations because they threaten, and the idea that only the state can legitimately use violence. So I think this whole debate and issue about terrorism goes much wider than just organisations like PKK, important as they are. My question was to Jan primarily, in terms of the whilst the case was ongoing over a number of years, was there a public campaign built around it in order to help to counter some of the political bias that was built into the prosecution case? And if so, what parties, what Belgian, what trade unions, political organisations, were they involved in that kind of public campaign, or was it just a very legal argument that was prosecuted, or the defence was taken on just a legal basis? Thank you.
And Akko, can somebody Mark, can you unmute Akko?
Akko, yeah.
Thank you.
Yeah, Akko.
Hello, everyone. Apology for being late to join you for other commitment. First of all, I would like to thank you, everybody, to organizing this event. And as Rosa said, we really appreciate you all have been involved with progressing this case and decriminalizing Kurdistan Workers' Party in a terrorist organization list, and also decriminalizing PKK. This is really important for us, and this is already being written in the history, so it makes a big difference for us, and not always say we have only mountain as a friend. So we really appreciate that, and it's an important support for all the Kurdish people around the world. My question was for the floor, actually, how important and effective the public campaign to delisting Kurdistan Worker Party in the terrorist list, and raising awareness, how legally effective this collecting thousands and thousands, hundreds, thousands of signatures and raising awareness in the grassroots community to support this case in the court, and also using this in the future in other part of the court sessions. Thank you.
Okay, thank you.
And then finally, Tony, before we go back to our two speakers.
Can I ask a question?
I think you can ask a question, Mark. Shall we let Tony and then you?
Yeah. Oh, Tony. Tony Cox has already had, yeah, he's already had one. So, yeah.
The question I was wanting to ask, it suddenly occurred to me, actually, is the status and position or potential position of bourgeois resistance theory within all this, particularly with regards to the legal aspect of it. You know, the medieval European states all sanctioned the right to resist through Thomas Aquinas, his right resistance theory, or right to resist theory, was pretty much general, one degree or another throughout the medieval states. And in this country, we have the Scottish resistance theory, which was both secular and religious, and was actually used to prosecute Charles I, and actually led to his regicide during the Civil War period, so-called.
Tony, do you have a question?
Whatever happened to bourgeois resistance theory, what status it actually has within law, either in this country or in any of the other European countries, because, it has obvious implications,
Tony, thank you very much. We've only got literally 5 minutes left. I'd just like to say, I mean, as inspiring as Jan's presentation and his example from the Belgian court is, I, to be honest, am not so optimistic in terms of the British state, because we have seen the British state over the last couple of years deepen its ties to the Turkish regime. Its economic ties have increased. British arms sales have increased. And my fear, actually, and I don't know whether Alistair or any of the other legal minds would agree, my fear is that rather than us being able to get the PKK off the list, my fear is that what the actual British state is trying to do at the moment is they're trying to get the YPG on the list. And I come to that conclusion by all the cases that the British state have been pursuing, targeting people who they think are easy catches. They haven't, they would never target somebody like Mesa Gifford, who is out there and very confident of his arguments for all the reasons that Jan went into, because there is no argument. I mean, the PKK is not a terrorist organization, and it's just a ridiculous political relationship that the British government have, very akin to the British relationship with the racist regime, the apartheid regime of South Africa. And I just like to ask Alistair, especially in summary, am I right to be pessimistic? And if that is the case, does that mean that activists such as ourselves have just got to redouble our efforts to try to raise as much awareness and support and in exposing the British government's relationship with the Turkish regime that is indefensible, but is very difficult with the label of terrorism hanging around. I'd also like just to acknowledge that Faik Yazizai is in the room as well, HDP, the European HDP representative. Sarah, can I invite Faik just to say,
yes, hi Faik. But we're not going to be strict about the 9 o'clock rule, by the way. I mean,
okay, that's good. Faik?
Do you want to say something, Faik?
I can't unmute. I can't unmute him for some reason. Oh yeah. Faik, hello.
Hello, hello.
Welcome to the meeting. It's great to have you here. Would you like to say anything to us?
Yeah, hello, thank you. It's very nice to see Jan there. I had listened to him in the conference in Brussels at the European Parliament. So Sarah was also there, and she wanted me to organize this meeting and contact him. So I made Sarah to contact Jan. So I'm very happy to help you to realize this meeting. And I really appreciate this meeting. It was really very fascinating meeting. So I want to thank to all participants and all speakers there. So I can say this, and I had already asked a question before. My question was at the European Parliament. So maybe I can repeat this question here. If it is possible to do something legal against the governments or the ministers who say that even the court decided that PKK is not a terrorist organization, but we will keep it in our terrorist organization list politically. So is there any legal way to start a process against these governments or ministers or authorities? So this is my question to Jan.
Thank you, Faik, very much.
Thanks, Faik. So can I suggest we have Stephen and then we have Jan to wind up at the end.
If Alistair could answer my question, I'd be really grateful as well.
Okay, I'm going to take these as quickly as I can and only deal with the ones that are directly relevant to me. Rose's question about, sorry, Faik, could you mute your microphone?
Yeah, I've muted, yeah.
Rose's question about starting building the case and how many people have come forward. There's a limit to what I can talk about due to client confidentiality issues. We've been engaging with various community members in London for over 6 months now and have potential clients, but things are progressing slowly, more slowly than we would like. And what is needed is community pressure to push it forward, for the community to come forward and say that we actually want this to go ahead, or alternatively for the community to say, no, this isn't the avenue that we want to go down. But it's important to note that this mustn't be a case that's by the lawyers. It mustn't be a lawyer's case. We've got a case that's ready and able to be put together, but it needs to be in the hands of the Kurdish community and not just lawyers. And that brings me on to Akko's question about the need to show broad community support for the case. That's what we need. We need to see as many potential clients as possible and people coming forward to say the PKK should be deprescribed, and this is why they are the legitimate political expression of our community. But a legal fight is only one part of a wider political fight that needs to involve the community. It needs to involve trade unions. It needs to involve supportive political parties. So we need that broad brush approach from the community, but also from other sectors in society, but also making sure that the legal fight is conceptualized as only part of a wider fight. If I can just briefly address Mark's comments about the YPG, putting them on the list of terrorist organizations, prescribed organizations, is somewhat difficult whilst they're not active in conflict with the Turkish state or the Syrian regime. But I am still somewhat surprised that the British government hasn't tried to prescribe the YPG. I think they probably haven't tried because it would be politically unpalatable whilst they're still cooperating with the Syrian Democratic Forces to fight Daesh and Daesh's remnants. But it may well be coming in the future. If there's anything else that anyone wants me to deal with directly, they can always contact me by just typing a message here.
Thank you, Stephen. Alistair, would you like to add anything to that, Alistair?
No, I agree with everything Stephen just said. I mean, I think if in terms of the legal challenges, absolutely. I mean, they're part of the political challenge, and the political challenge, answering your question, is very difficult. What I was very concerned about, Jan referred to the case at the EU level, dealing with money laundering, etc., in relation to PKK. There was one country that decided to intervene to try and keep the PKK on the list, and that was Britain. It was not invited. It obviously did it for its own political reasons. And that's quite a clear indication of what the state level view is in relation to Turkey. And in relation to recent prosecutions, again, it's unclear whether one can say it's a trend, but it's very worrying that people are being prosecuted now, when in effect they weren't being prosecuted for the last 2 or 3, 4 years for the same behaviour. And again, it's, you know, one has to see it in its political context, and it's not a positive trend.
Yeah, that's what I thought.
Would Jan like to wind us up and last word?
Well, maybe there were a few questions directly to.
Yes, yes. Oh, yeah, with answers to the questions, of course, as well. Yeah.
Feig asked in the Parliament and asked again today whether the Belgian Minister of Foreign Affairs, who immediately after the court gave its decision, said, "Yeah, but we can still consider the PKK as a terrorist organization," whether we could bring up some case against him. And I will answer as I did in the European Parliament. Unfortunately, under Belgian law, talking rubbish is not a crime. So no, you can't make a legal argument directly out of such a statement. He should, of course, also politically take into consideration the fact that a judge decided that this organization in particular could not be considered as a terrorist organization. But I think the real legal case about this, the real place where this is going to be discussed is, of course, the European Court of Justice, where the cases, the follow-up cases on the listing are coming up in the near future, and where actually the opponent, the other party is the European Council, which means including the Belgian government, of course, because Belgian government is part of the Council of Ministers. So you can't bring up specifically a legal case, and I don't think that would be of any use also to do it. But politically, of course, you can use the decision, and also in the case in Luxembourg, in the upcoming case in Luxembourg, the Belgian decision, I'm sure, will be used to argue in favor of delisting on a European level. There was a second question about the UN, and to be very honest, I've been several times the last years, the last 5 years, let's say, maybe a little bit more. I've been very active on different questions and on the Kurds in the Human Rights Council sessions in Geneva. And I think that is a UN forum. That is actually the main forum where these questions are discussed or should be discussed together with the General Assembly. But generally, if you can get it moving in Geneva in the Human Rights Council, then you have a platform also to do something in the General Assembly in New York. And I'm going to be very honest with my Kurdish friends. I'm always surprised by the fact that they are completely absent from Geneva. So I think there is an area there, a field of action, possibility to do a lot of work with governments and also with NGOs that my Kurdish friends are missing. I'm always surprised that the human rights violations in Turkey, the violations of international law, of fundamental rights, people's rights, individual rights in Turkey, especially in relation to the Kurdish people, are as good as absent from the discussion in the Human Rights Council in Geneva. And I definitely think that is a missed opportunity. I definitely think that is a battlefield where the Kurds should be present and should make themselves be heard. It's even more necessary because the NGOs that try to somehow sometimes do something about the Kurds are under very strong attack by Turkey. A very respected, well-respected NGO called Setim was actually suspended for a year from the Human Rights Council because of a complaint of Turkey, because that NGO in some, I think in a text or in a statement, used the word Kurdistan. And so Turkey immediately jumped on that and got this NGO suspended. And I think if there would be more activity, NGO activity in the Human Rights Council on behalf of the Kurds, that definitely would have been more difficult. And then the last more global question, and I think that's maybe a also summing up a little bit the discussion. There were some questions about public campaigns. What role did public campaigns play or can play in getting things moving on the judicial level? It's obvious that I would say public campaigns influence the public, and judges are to some extent part of that public. So if you want to try to use the cracks in the system, if you want to try to benefit from the cracks in the system and trying to use these to your advantage, it's obvious that at the same time having a political campaign, strong political awareness, strong awareness in the public opinion is very important. In this case, which we dealt now with in Belgium, I would say there was less focused attention of a campaign on the case as such. There was less attention now than in the previous case on MetTV in the 1990s, where there was a very strong campaign on the freedom of expression, and that was much less now. At the same time, of course, the role played by the Kurds in the Middle East somehow created a form of sympathy on a broader scale, which to some extent made it also easier for us. For example, and that kind of sympathy, or that kind of awareness also plays in the judiciary. When the case came for the first time to this preliminary court, the investigating judge has to make a report on his investigation, an oral report on what he has done and what that kind of evidence he collected. And so generally the judge will say, and I tapped this phone and we did some search operations there, and we had witnesses from there. So we'll give an overview of what has been done. And to our big surprise, in this case, the investigating judge said, as an introductory statement, actually as the only statement he made in the court, as the only report he made in on the case, he said, I was told in the beginning of this case, when I started my investigation, I was told that these people were very nasty, very bad people. And actually, throughout the case, I'm not quite sure that that is the case. Now that I heard more about it, and now that I was able to study it more, I'm not quite sure that we know what we are doing here. These might be also freedom fighters. Thank you very much. End of statement. So, I mean, it shows that also within the judiciary, there are different opinions. The prosecutor was shouting that these were terrible terrorists and massacring children and whatever. And the investigating judge actually openly said in court, I'm not quite sure that these people are nasty. They might also be freedom fighters. Thank you. And so I think we have to use those cracks. You know, my US colleagues, in relation to the way the ultra right is using law, especially in Latin America, against Lula and against Maduro and against the former president of Ecuador, etc. They and also the way multinationals are attacking lawyers and victim communities, etc. They use the term lawfare instead of warfare, lawfare. The opposite side using law to crush you, using law to attack the left, using law to get their ultra-right program. And I think what is happening with the criminalization of the Kurds in Europe is lawfare. It's use of the law as a continuation of the war the Turkish state with the solidarity of the European government is waging on the Kurds. I think we should reinvent guerrilla lawfare on the other side of the barrier of the frontier. We should find against this overwhelming legal offensive, which of course will not stop, which of course will try to take different forms. We have to find the weak points, and with the forces we have, attack on these weak points, use this, raise public support for this, but also really use the cracks and the weak points on the other side, because there are cracks and weak points also on the other side. So I think this is a basic principle of how to wage war when you are in an inferior position of inferior power. It's the same principle on the battlefield and in the courts.
Thank you very much indeed. Thank you to two fantastic guerrilla lawyers. Well, three guerrilla lawyers maybe we had tonight. And thanks to everybody who came and joined us. If you have friends who would like to have seen this and missed it, it is on YouTube, which is the links on all the notices. And I hope that some of you will join us in 2 weeks' time when we will be talking about boycott Turkey. Thanks very much indeed.
Bye.
Thank you.
Thanks.
Thank
Bye.
you. Thank you.
Yes.
Bye-bye. Thank you.
We've unmuted everybody, so everybody can.
Thank you, everyone.
Thank you.
Bye.
See you soon. Bye.
Bye. Thank you for having us. Bye-bye.
Thank you very much.
Thank
indeed.
you, Alistair.
Bye. Thank you very much.
Good night. Bye-bye.
Good night.
Bye.
Galaxy Pass.